fellow of the Center for Public International and Comparative Law there at the law school. So he teaches courses on constitutional law, comparative constitutional law, and legal history. And he's published articles recently in the University of Toronto Law Journal, the American Journal of Comparative Law, Law and Philosophy, the Sydney Law Review, the Melbourne University Law Review. And he's also written several books, including Constitution of a Federal Commonwealth, The Making and Meaning of the Australian Constitution, Freedom of Speech in the Constitution, and an edited book on restraining elective dictatorship, the Upper House Solution. And he's currently working on several books, Jurisprudence in a Federal Commonwealth, which I assume is on Australia, and Sharia in the West, and also a book on constitutional federalism theory and practice. So it's a great deal of pleasure that I introduce to you Professor Nicholas Aroney. Thank you.
Thank you very much, Professor Kincaid, for the opportunity to come here, for your hospitality. It's most appreciated. Thank you everyone for coming. Professor Kincaid asked me if I might speak briefly for around half an hour on the topic of a comparison of the Australian High Court to the US Supreme Court. So I will endeavour to do that by first of all introducing the High Court of Australia and situating it into the structure of our system in Australia. And to do that, I'll explain something of our system as a whole, and I hope in a way that will help you to relate it to your own system here. And I'll talk a little bit then after that about the functions of the High Court. And in particular, what I'll do is I'll discuss a few cases. And the cases that I'll discuss have some relevance to, first of all, what is characteristic about the Australian Constitution, and also, I hope, in a way that's relevant to your own system here. Because I do think that by comparing your system to other ones, it can help us all to understand our own systems better, understand what's distinctive about them, what's important about them, and that can also help us all to learn about how our systems can be improved, where the strengths lie, and perhaps where the weaknesses lie as well. So that's what I aim to do. Now, Australia and the United States have a lot in common. They are, from a European point of view, settled countries, part of what could be called the New World, although Australia as a continent was cloaked in even more mystery, I think, than North and South America, and was colonised a couple of hundred years later, or more like about 150 years later. But has a lot in common because it's a nation that is continental in scope. In fact, it's the only nation state that occupies an entire continent. And it's also similar to the United States politically and constitutionally. First of all, it's a federation. It's a federation like the United States. And it's a federation like the United States in one very important sense. And that is that the national government came about on the foundation of pre-existing state governments and was formed when political leaders amongst those states thought it worthwhile to form themselves into a federation for national purposes while retaining the existence and identity and self-governing powers of the states as constituent elements of that body politic. And I think that's a very important thing to remember when understanding the Australian system, and I'd even submit the American system as well. Now, my subject, of course, is to get to the courts, but I think it's important that you appreciate that federal foundation to the system. Another important thing to bear in mind, and I'm turning now to the Australian Federal Constitution, which parallels your US Constitution. And that is the structure of the Constitution itself. Like the American Constitution, the Australian is divided into 3 preliminary chapters, chapters 1, 2 and 3, which correspond precisely to your Articles 1, 2 and 3, dealing respectively with the legislature, the executive and the judiciary. And like in the United States, it's understood that that division of the Constitution into 3 separate chapters, or articles in your case, is understood to be the case in order to make room for or provision for the doctrine of the separation of powers. So just like in the United States, and even more so here it would have to be said, that you understand the separate chapter article divisions as giving effect to the notion of a separation of legislature, executive and judiciary, albeit with checks and balances between them, so that there's a lot of discussion about exactly what that separation means, and what the also intermeshing of the elements of government, or branches of government mean. So too in Australia, the idea that we have these separate chapters implies a separation of powers. Except that, in one important respect, and that is, Australia, like the United States, is federal and has a certain degree of a separation of powers. But Australia also draws from the British system of government, which is known as, variously, parliamentary responsible government, or the Westminster system. And in a parliamentary system of British provenance, like the Australian and also the Canadian, there's a close relationship between the legislature and the executive, closer than it exists here in the United States. So that even though your president just recently spoke separately to the members of Congress from the 2 parties here and tried to create some dialogue, there's an even closer relationship between the executive and the legislature in Australia, and that always needs to be borne in mind. And I don't have time to explain that in any detail. In fact, I'll probably be touching on that in a later class later this afternoon, and I'll talk about that in more detail then. Now, bearing in mind the division of the Australian Constitution into those 3 separate chapters, it's Chapter 3, like your Article 3, that deals with the judiciary, and in particular, the High Court of Australia, just like your Article 3 deals with the Supreme Court. And because of that doctrine of the separation of powers, because you're dealing with the judiciary now, and not the legislature and the executive, it is the view in Australia that that separate treatment of judicial power in Chapter 3 implies a strong and important separation between the judicial branch of government and the, as it were, political branches, if you want to call them, of the executive and the legislature. And that has proved important in several respects that I might expand on a little bit shortly. In Chapter 3, there's provision for the High Court of Australia and such federal courts as the Parliament of the Commonwealth, that means the federal equivalent of your federal Congress, should think fit to create. And our Parliament has thus constituted the High Court of Australia, although the Constitution requires that to be the case, and has also chosen to create a federal court, named Federal Court, as well as another specialist federal court which is called the Family Court of Australia, which deals with family law related matters, marriage, divorce, and those sorts of custody of children after divorce, and property arrangements and maintenance and so on between the divorced couples. And so there's provision for a federal system of courts, just like here in the United States. Slight differences, though, need to be noted. Like the US Supreme Court, the High Court of Australia has a specialist jurisdiction, if you like, which in looser terms we might call constitutional. And in fact, technically the High Court of Australia has very similar jurisdiction to the US Supreme Court, because in technical terms it has jurisdiction in matters arising under the Constitution and under federal legislation.